It is 1 o'clock sharp on my clock. I'm ready to roll if you are.
Yep.
Ready to do it?
Yep.
All right, let's light this candle. Welcome to the smartest people in the room. We are so glad you are here with us, and just by showing up today, you are already demonstrating your very own smarts. Today, I'm pleased to feature two of the smartest, most interesting, and outspoken music industry executives that I know. And I promise you will leave today smarter and more inspired than you arrived. Before we get started, please let me take care of some business. First, to the audience, please feel free to introduce yourselves in the chat window. The reason we do these webinars is twofold. First, we want to showcase really smart people and the amazing work they do day to day in the music industry. The second reason is a bit more nuanced. Many of you know that I am a music industry headhunter. I run the music practice at Turnkey ZRG, and I place music executives in roles throughout the industry. So by definition and function, I help people connect with companies. And in this series, my goal is to help you make more connections, and I invite you to take full advantage of that opportunity. Specifically, I invite you to engage with the speakers and the other attendees in the chat of the Zoom. Please introduce yourselves, share your LinkedIn profile, say hello to your friends, and please make some new ones. And ask questions of our speakers. We will try to address as many of those as possible during the session. Also, please make sure your chat is set to address everyone, not just the speakers. I want to thank our program sponsors, for without their support, we could not keep this free. Special thanks to First Horizon Bank, Turnkey ZRG, the Tennessee Entertainment Commission, MedJet, Tennessee Brew Works, Project Music, and Cushmasters. So let's get down to business. And today we welcome Chris Castle and David Lowery. Chris runs his own law firm based in Austin, Texas. He founded the firm in LA in 2005 and moved to Austin in 2011. He works on a variety of transactional matters in the nexus of music, technology, and policy. He has worked on many high-profile cases for a myriad of global clients, including the World Intellectual Property Organization. Chris is a frequent speaker at professional conferences, including the American Bar Association, the State Bar Associations of California, Minnesota, New York, Texas, Tennessee, California Copyright Conference, Copyright Society of the USA. He has testified on artist rights issues in the UK Parliament, briefed the National Association of Attorneys General about brand-sponsored piracy, spoken at congressional seminars and lectures at law schools and business schools in the US and Canada on music tech issues and artist rights. Chris was the founding chair of the Austin-Toronto Music City Trade Alliance, is the director of the Texas Entertainment Law Institute, and is the legislative chair of the Entertainment and Sports Law section of the State Bar of Texas. In 2005, Chris was elected as a fellow of the World Technology Network. Prior to founding his firm, he was SVP and general counsel to Snowcap in San Francisco, of counsel to Wilson, Sonsini, Goodrich, and Rosati in Palo Alto, and Mitchell Silverberg and Nupp in Los Angeles, SVP of Business Affairs at Sony Music in New York, and VP of Business Affairs at A&M Records in Hollywood. Welcome, Chris. So glad to have you with us today.
Thanks, Tom.
And joining Chris for today's discussion is David Lowery. David is a mathematician, educator, musician, producer, and artist rights advocate based in Athens, Georgia. While studying math and computers at the University of California, Santa Cruz in the early 80s, David founded the critically acclaimed ensemble Camper von Beethoven and associated record Pitch Tent Records. With these two entities, he helped jumpstart the indie rock movement. In 1991, David moved on to the alt-rock ensemble Cracker, which produced 3 top 10 alternative rock tracks and 3 platinum albums. He also produced and recorded albums by artists such as the Counting Crows, LP, and Sparkle Horse. David is also one of the key contributors to the blog, The Tricordist. This blog examines artist rights in the digital age. David is an artist rights advocate and has been featured in the New York Times, Billboard Magazine, the Washington Post, Business Week, and on CNN. He began teaching at the University of Georgia in 2011. He teaches classes on economics and finance of the music business, as well as music publishing and licensing. Along with Steve Winogradsky, I hope I got that right, he is co-author of the textbook Music Publishing, The Complete Guide. Gentlemen, it is such a pleasure to have you. I've been stalking you both for a long time to be here. Thank you so much. Take it away, please.
Hey, thank you.
Well, thanks, Tom. So we're gonna talk a little bit today about the Copyright Royalty Board, basically, and the current meltdown going on with songwriter royalties, and what we think can be done to make it better, which is kind of the role that we play a lot in terms of being critical of what other people do and explaining to them how they need to get up on that 7 terrorist summit with all the rest of us, So this isn't meant as a pejorative or an attack on anyone, but just, from observation that we have a few thoughts about it. So to just kick that off, David, why don't you give a little overview of songwriter royalties for people who are not in the know on that, in the detail that we're going to need.
Right. So yeah, like Chris says, a lot of what we do revolves around songwriter royalties. These are things that we might, join together on a letter for, or we work in parallel on, or just completely randomly apart. I see that there's a lot of publishers and songwriters here already, so that's great. But I know some people are sort of mystified by exactly what songwriters are and what they do. So basically, a lot of songwriters, as opposed to performers, you may be a performer, you may also be a songwriter, or you may be separately a songwriter. You get paid for your songwriting. And this is a separate stream of revenue than the performer may get, right? And typically there are 3 ways you get paid as a songwriter. One is when your song gets licensed for television or film or a video game or something like that. The second way is when it's publicly performed on television and such. And the third way is something called the mechanical royalty, right? And the mechanical royalty covers everything that's sort of like sales or rental or streaming, right? So a mechanical royalty is the royalty that songwriters get paid. For instance, if a CD is sold, or a vinyl album, or a cassette, or a download, or streaming, right? If a song is streamed. This is a pretty important stream of revenue for artists. If you are an artist that has hits, the mechanical royalty might be around 35% of your revenue. Because see, if you have hits, you might get some licensing. But if you don't really have hits, I'm going to say you're in a really popular metal band, but you're not really going to get played on the radio or anything like that, it's going to be more like almost 50% of your revenue as a songwriter, right? So it's a very important stream of revenue. Now, the curious thing about the mechanical royalty for songwriters is that there's something called a federal compulsory license. That is, somebody who wants to use your song, as long as they follow the rules set out by the Copyright Act, they get to use your song, right? And that's interesting. It creates market efficiency. We don't have to spend all this time writing contracts, negotiating with each other, playing phone tag, do all that. There's just a license that sits there. You follow the rules, you get to use the song, right? But the other side of that, though, that's less satisfactory for songwriters is that, well, how do you set the price, right? You have to set a price for this use, and how is that done? So the way that happens is that there's something called the Copyright Royalty Board, right? And a lot of both me and Chris's activity lately has centered around what happens at the Copyright Royalty Board. Maybe you should explain some of that, Chris, what's been going on.
So the Copyright Royalty Board is kind of a logical extension of the compulsory license. If the government's going to take away your right to negotiate your own deal, which they did for songwriters on mechanical reproductions in 1909, so it's been a problem for quite some time. The government has to be able to tell you what rate they're going to let you charge on your behalf for the use of those songs. And remember, mechanical royalties are really historically, they're for the reproduction of the song in a record, let's say. And then since streaming has come along, there's now something called a streaming mechanical, which covers the reproduction of the song to the extent there is one in a stream. That issue, I think, has been quieted down now, but that was something that people were arguing about for a while, so whether it even was a mechanical in a stream. So the way the government has done this is that they have appointed some agency, either Congress has done it themselves, or they've created some agency to set those rates. And it's gone by different names at different times, but the most recent iteration is called the Copyright Royalty Board. And this is set up by three people who are called, or it is convened by three people who are called copyright royalty judges. And they sit in Washington, D.C. For reasons of geographical convenience, I think, because there's really no reason why they have to be in Washington, D.C. And lobbyists and lawyers, and a lot of lawyers, come in and argue to the Copyright Royalty Board about the value of a song. And the way that goes is usually the music user, whether it's a record company or a digital music service, brings in their expert, and the publishers and songwriters bring in their experts to argue about what the value of the song should be. And the way this goes down is usually very argumentative, and it has gotten increasingly argumentative over the years, and a very costly hearing. These hearings can end up costing something like, just to pick a round number, $20 million, probably higher, in legal fees and expert costs. To do what? To determine what a willing buyer and a willing seller would have paid in the absence of the compulsory license. And of course, there never has been a willing buyer and a willing seller making this transaction. I mean, there are some benchmarks out there. There's some voluntary agreements. There's some things that people put forward, their experts put forward. But in reality, in the marketplace, because there's a compulsory license, there's never really been a truly willing buyer and a truly willing seller when the seller could walk away, right? And so consequently, what this means is the judges guess. They may make an informed guess, but it's a guess. And you say, well, why do we need them? I can guess. I don't need to have all these expenses for all these lawyers. And you'd be right. You can guess too. Why do we need them? So that's one of the issues we're going to talk about today. And by the way, the copyright royalty judges, even though they're called judges, are not judges. Just to make it even more Kafkaesque, they are administrative law judges. They are not what we would call Article 3 judges. In other words, they're not members of the judicial branch. And their work is reviewed by members of the judicial branch, because whatever they decide can be appealed to the DC Circuit, District of Columbia Circuit Court of Appeals, reviews their work. And so that's the Copyright Royalty Board. They're also subject to something called the Administrative Procedures Act, which is why in the case of the frozen mechanicals.
Well, wait. We should explain what that is before we can even go there. I mean,
The frozen mechanic, which?
Yeah, well, let me explain the frozen mechanic.
Yeah, okay, go ahead.
Yeah, just because nobody's going to understand this. Now, I realize I realize there's a lot of songwriters and even some publishers here. And what I find, even talking to my friends, a lot of people they're just like, a check comes in the mail from somebody and they don't really know how that number was arrived at. So one of the things that happened is this Copyright Royalty Board has had a couple of big deal cases to the music industry before them, or proceedings before them. And one is for the streaming mechanical, which we'll get to in a minute, and the nightmare associated with how that's been going. But the other one is for downloads and for vinyl and CDs, which some people think of it as a small part of the of your revenue, but it's actually quite important if you're an independent or sort of middle tier or niche artist. You sell a lot of vinyl and you have a lot of CDs. Okay, so Chris references the frozen mechanical. Well, this is because since 2006, am I correct? Is it 2006?
Yeah. Mm-hmm.
In 2006, that was the last time the mechanical rate, the royalty for downloads, CDs, vinyl, cassettes, anything like that was changed. And it was set to 9.1 cents per copy, per song, per copy sold, right? So if you had a 10 song album, the songwriters got 91 cents, right? Makes sense? Okay. So in 2006, that was the last time it was raised. And every time there's been a proceeding since then, the royalty rate has been frozen, right? It's just been left at 9.1 cents. And we've had this kind of curious situation where essentially major publishers, and there's an argument for why they did this, have argued to leave the rate as it is, right? And so let's see, vinyl's gone from about 17 bucks a copy to about 35 bucks as of last week in your typical, store when you go and buy a vinyl album. It's pushing like 35 bucks now, right? But our rates as songwriters haven't changed, right? And so this is sort of kind of appalling to people like me, especially because the publishers, if you don't understand what a publisher is like a record label, except they sign songwriters and own songs, not recordings, right? So the publishers have sort of agreed with this freeze, which is just really, really perplexing to songwriters. And we weren't, normally the publishers are in these hearings, and there's usually one or two songwriter groups. But it was just sort of, a lot of songwriters were bewildered by the fact, once I explained this to them, why would the publishers agree to freeze our rates, right? So what happened was the last time this sort of ruling came about, somebody, maybe Chris Castle, noticed that in the publisher's filing, they made reference to a memorandum of understanding, right? Okay, right. So why would the publishers agree to freeze the royalties with the record labels for songwriters, right? Because that's their money, they would get that. And Chris noticed in one of the filings that there was a reference to a memorandum of understanding between the publishers and the record labels. And that's where our latest adventure kicks off. Why don't you explain that, Chris?
So the memorandum of understanding, this is not the first time this has happened, right? Because just to fill in another fact, these rates get set every 5 years. So this freeze had happened 3 times in the past over the last 15 years, let's say. Thereabouts, 14 or 15 years, depending on how you count. And the memorandum of understanding relates to a completely unrelated, as they said, as the publisher said, a completely unrelated transaction, which is a settlement of the so-called late fee waivers. And I don't want to get too sideways on that, but late fee waiver, there's a late fee that's paid by a music user if they don't account and pay royalties on time. Obviously, with the major labels, it's not like they're not paying royalties. They are paying royalties, and they may pay them late. They deny that it even applies to them, but there's usually a settlement, right? So basically what was happening was, if you signed up for the late fee settlement and you gave up the 9.1 cents, there was a quid pro quo, right? I'm getting something over here, a lot of money potentially, because they keep that number pretty quiet. But the last time it got reported on in Billboard, it was over $200 million, right? So you'll say, I'm getting access to a bunch of money over here. I'll take a freeze on the mechanical royalty over here as additional consideration for getting this settlement.
Right, with the point that I didn't make, think this just, I'm looking at some of the comments here. The Copyright Royalty Board is deciding on this rate with record labels on one side of the table and publishers and songwriters on the other side of the table, right? So it's kind of weird that there's this side agreement between the two sides of the table, right? It looks like a judicial proceeding, but it's not. I'm sorry, go back.
Right. And remember, they've divided these proceedings into two, right? So you have the physical download music bundles, on one side, and CDs, and then you have, and that's with the record companies, because the record companies are the ones who are paying those rates. And then on the other side, you have the streaming mechanical, which is not involved in the freeze story. And that's with the digital music services and their 38 lawyers and the NMPA, right, on the other side. So we're not talking about the streaming piece yet, but we're just talking about the frozen part. So when you realize that there's this additional consideration from a deal that has not been put on the table and the judges don't know anything about, but they're being asked to freeze the rate in this supposed voluntary settlement, the judges are looking at this saying, well, wait a minute, you want me to read this into the law? Because if I accept your settlement, and there's a bias towards voluntary settlements, they're supposed to try to accommodate voluntary settlements. If I take your voluntary settlement, then there are going to be people who are not able to claim a share of that MOU settlement, but who are going to have this frozen rate imposed on them. So if one is consideration for the other, not everyone, like a lot of foreign writers, for example, are going to be able to get access to that settlement. So the judges rejected that settlement after they got a ton of comments about the issue that were negative, one of which was written by one David Lowery.
Well, and there's also some of our letter writers are in this, are in the audience here tonight. I can see a few of them.
Yeah, and there were a bunch of other people. There were a ton of other people. I mean, there, Roseanne Cash. I think I saw Michelle Schock. She wrote one.
George
Eddie
Johnson
North wrote one.
Well, George Johnson was opposed to this the whole time.
And then let's talk about George Johnson. So one of the problems that we're going to try to solve today, or start us on a conversation to solve, is the fact that it's really expensive to participate in these things. So virtually no songwriters actually participate, except for George Johnson, who is a songwriter in Nashville, who is appearing representing himself in this proceeding. And if it weren't for George Johnson, I will tell you, I'm pretty confident that we wouldn't be in the situation that we're in, because at the moment, the deal that's on the table is no longer 9.1 cents, it's 12 cents, right? Which
maybe
is like
even 13, depending
maybe
on how
even 13,
how you calculate it.
Yeah, depending on how you calculate it. So George, if George wasn't in there and George hadn't objected to the settlement, it's possible that the judges may have said, well, no participant in the proceeding objected, even though we had these members of the public who are affected by the outcome, but who are not participants. Even though we had those people, we didn't have a participant. So we can't acknowledge these objections. I don't think they would have gone there, but they could have, right? And this gets back to the Administrative Procedures Act and why they're different than Article 3 judges, judicial branch judges, because there's at least in the case of these settlements, they're supposed to put the proposed settlement as a proposed rule out for public comment. And that's why the public was able to comment, because you probably are thinking, I don't know of any judge that puts their decision out for public comment and changes anything, right? Right. And you'd be right. That's because they're not really judges, even though they're called judges, right? So just to make it that little extra piece of weird, So that's how we got to where we are now, right?
Right. And I want to put this out. I mean, it was sort of a songwriters, sort of citizens revolt in a way, which I don't, that's one of the sad things is people don't realize that you can do these things as a citizen. I remember actually, as a good story, as an aside for how these things kind of work, there's one company in Silicon Valley that was basically enabling a lot of piracy. And I also noticed that also they were hosting a website for one of the Donetsk Republic banks, which were sanctioned. And so I go, this has got to be illegal and a way to report it, right? So I just look on the Treasury website, dig around for a while. Sure enough, I find a form for reporting this. So I report it, right? 2 days later, I see in the Wall Street Journal that this company restates their earnings with a note saying that they may have violated Treasury sanctions. So it's this kind of activity that I particularly like myself, right? This sort of asymmetrical, just try this, see what happens type thing, right? This sort of seemed like one of those things where it's like, okay, we're going to get screwed on the mechanical royalty on physical, on vinyl, which is starting to be something like 40% of my revenue because I'm a niche writer, performer. We're going to get screwed on it again. Let's just go ahead and try and see if we can write some letters in the public comments, and stuff like that. And a lot of other people have the same idea. You'd be surprised how often this kind of stuff works. And that's where Chris has often come in handy, because he often we can watch what Chris does and what his legal arguments will be in his letter. We go, aha, okay, so that's the actual law that we need to be addressing here, right? So,
well, and we should say we had a lot of people participating who were
Kevin Cassini's here.
I see. Cassini and Rick Carnes and Charlie Sanders and the Ivers Academy, and
that's the British songwriters.
Yeah, they do the Ivers Awards, and Helene Lindvall and Blake Morgan, and we had a lot of people. And the Songwriters Guild really did spend a lot of time, getting their comments in great shape, and they were very persuasive, I thought. And so consequently, when the judges issued their order rejecting the settlement, that kind of caught people off guard, right? And fortunately, and we really have to commend the labels on this. The labels did come to the table, and without a lot of struggle and with no litigation, although they kind of took a wrong turn with one move, but so it wasn't a complete victory, but it was. They withdrew that later, but they really did, especially Universal, really come to the table to try to make it right and do get to a good result, which I think they did. Now we'll see. The judges may think it needs to be more, but where it stands right now is it's about a 35% increase without really having to fight about it much. Although we have a lot of people on our side,
This is potentially tens of millions of dollars to songwriters over just at least over the next 5 years. So this isn't like just let's fix this little tiny thing. This actually is real money, and it's sort of about that revenue. I can't express this enough. That revenue is progressive in it sort of waters the bottom of the market, right? The niche writers, the middle class writers, because physical is still so important to that part of the market, right?
Yeah.
The up
So
and
one
coming
of the
writers.
things that we discovered from doing this is that, the CRB really just doesn't work. It just does not work the way it's currently set up. And so, one of the things that we've been thinking about is what would we do differently? How would we do it differently? Because as long as we have the compulsory license, we're going to have something like the CRB to tell us what the rate is that they figure out from these various methods.
Yeah,
But
if
it's
we're going to
got-
use a compulsory
ahead.
license, there has to be some sort of process for doing this, but
Right.
it can't be gamed like it has been.
Yeah, exactly. And what's going on right now on the streaming side.
Yes, and this is the outrage. This will literally make you say, why haven't these streaming companies been canceled? Why haven't there been like newspapers articles on this? So do you mind if I explain this?
Yeah, you go ahead.
I was so appalled. You should actually read a message from an open letter that I had. My dog passed away during the pandemic. I have another dog now, though. And I had my dog, in the voice of my dog, write an open letter to Jeff Bezos. And what it was about was the fact that streaming mechanicals, it's no secret that it's pretty absurdly low. So in 2018, when the judges reset their rates, they gave a raise. And it basically increased by about 50% over 5 years, correct, Chris? It goes over 5 years. The streaming mechanical rates are
not quite, but yeah.
Okay, but anyway, and it was a raise each year, right? And so what happened is we probably got paid that for about 15. We got our first raise. We probably got paid that for about 15 months. Then April 2020, what was happening then? Were you leaving your house at all in April of 2020? I mean, I was going in the grocery store, maybe one person at a time at that point, right? The streaming services appealed the raises that songwriters were given, right? Retroactively actually appealed the raises that songwriters were given.
Well, they appealed. It took a while. Yeah, it took a while for the right to appeal to ripen.
Well, right, but April of 2020, suddenly our songwriter pay is basically slashed. At the same time, we have no shows.
I think that was when the remand was granted. I think that was the logic. Is somehow they were going to pay it pending the outcome of the appeal, and then when the remand came in, which sent the case back to the Copyright Royalty Board, then they decided to cut the rates back to the pre Phone Records 3 rates. Yeah,
we lost our raise, and it was just spectacularly ill-timed. And
right.
part of the outrage that Chris is talking about when you say that the Copyright Royalty Board doesn't work well is how essentially this was done. So, well, first of all, I actually think the judges are very sympathetic to songwriters. More, I think they try to hide it because they have to be impartial, but I actually think they're pretty sympathetic to us. And what we have is a process that can be totally derailed. So we were supposed to get this raise that went 2018, 2019, 2020, 21, and 22. We are at the end of it right now. We are at the end of that period. We still haven't got are raised, because basically, if you have money, if you have lots of lawyers, if you're a multi, $1 trillion company like Google, YouTube, right? You can endlessly delay these proceedings. And that's what's happened, right? So I could have used that 50% raise over the last, and many of you out there could have as well. So how did this happen, Chris? How do they do that? How do they delay a raise for 5 years that we should have gone?
Well, the main way these things happen, all of these different outrages happen, is that there aren't any rules in place to keep them from happening. That's the main thing. In other words, if you said, yeah, you want to appeal any case, you'd have to post a bond, right? It'll change, depending on what the case is, but there's something, you've got to have some skin in the game, if you're going to appeal. Copyright Royalty Board, we just won't pay that higher rate, right? We'll decide, we'll decide. Yeah, we don't think we should pay it. Well, what a shock. So basically what happens in the Copyright Royalty Board is there's no limit, and this will be sort of foreshadowing some of our recommendations here. There's no limit on the number of lawyers who can participate. Now, remember, the Copyright Royalty Board was not designed to be used by the biggest corporations in commercial history, right?
Apple, Amazon, Google.
Yeah, Amazon, Google, Apple, right? Although Apple's actually been a pretty good player in this, but Google, Amazon, Apple, Spotify, Pandora, big publicly traded companies, right? Who really don't have many constraints on them. And frankly, if you thought of what kind of legal forum could I come up with that would most favor the big and the rich and the powerful, and is most likely to further the proposition that the rich get richer, it would probably be something like the Copyright Royalty Board. There's no jury, right? There's no limit on the number of lawyers who can appeal. There's no limit on the number of appeals, right, that you can take. So you could basically just, wash, rinse, repeat, for quite some time on all these decisions. And they're just, the people who are really, and this is all designed to figure out the value of a song, okay, right? And they've got 38 lawyers in the streaming mechanical piece, 38 lawyers. And they're not just, guys down the street. This is Wilson Sonsini, like all these big law
the most
firms.
Powerful.
Yeah.
It's like all the white shoe firms, right? Wouldn't that what you call them?
And the combined billing rate of these characters has got to be $100,000 an hour. It's got to be. It's got to be. And, and you've got the songwriters and the publishers, represented by the same law firm, which, bless them. I mean, I'm not casting aspersions about the lawyers, but that's not a situation they're probably particularly comfortable with. Wouldn't it be better if the songwriters had their own lawyers? Yeah, I think so. But can they afford it? No. Right. And the only person who's an actual songwriter who's a participant in the proceeding is George Johnson, who, bless his heart, has been in there on his own dime, representing himself for I don't know how long, like 10 years he's been doing this, right? Well, one day George Johnson's going to say, I don't need this anymore, right? I'm going home now. Y'all figure it out. So this leads
George Johnson's on this conversation here. Everybody
George is here.
Yes, everybody owes him a big.
I'm saying nice things about you, George. Don't forget.
Yes.
No, George is a great guy. So, and George and I have one thing in common. George wrote a song called "Still Pissed at Yoko." So, as someone else who's still pissed at Yoko, we immediately bonded.
Yes.
So let's think about like what this ought to be. Okay. And David, do you want to lead that, or do you want me to kick it off?
Well, okay. So
I mean, I think we've talked enough about.
Yeah. So since this board basically sets like at least 35% of my revenues, and maybe even closer to 50% at times. And I feel like everybody else out there that's a songwriter or publisher probably, this actually isn't some little obscure thing. This is something important for us to get right. I mean, so I think, so a number of the things we thought, or, you know, a number of us have been discussing, one of the things is there should just be like essentially a kind of ombudsman, or, you know, somebody appointed to represent songwriters who can't travel to DC, who aren't willing to become like essentially the jailhouse lawyer like George Johnson did, where he taught himself the law, right? We need somebody formally a part of this process that has to work in the fiduciary, you know, interests of songwriters, like have their, you know, somebody has to be part of this process. And it can't be just, we can't just rely on, you know, oh, well, this songwriter will care enough and that songwriter will care enough to spend $180,000, like, you know, defending their royalties in this court, right? So one thing that and you know, there's other cases where, or there's other parts of government where you have essentially somebody that's appointed to do this. That's one thing. You had some ideas, Chris.
Yeah, yeah. Well, and one other fact about this that it's important to remember: the government set the mechanical royalty rate in 1909 at 2 cents. 2 cents. It did not change until 1978. It was 2 cents through 2 world wars, a pandemic, Great Depression, right? Ups and downs, CDs, the Beatles,
Cassettes, 78s,
2
everything.
cents.
Yeah.
You know, everybody else got what they got. You songwriters, 2 cents. And then in 1978, they decided to change it and increase the rate gradually over time. There's an argument that that rate should have been indexed to inflation at some point. And particularly in 1978, if they had indexed that rate to inflation, it would have gone from 2 cents to 48 cents, right? Which sounds, you know, not like something the government won't do, right? Because it's such a sudden and large increase, but it was absolutely justified, right? Because you haven't even started talking about the value of the song, right? With indexing, you're preserving purchasing power. With value-based increases, you're talking about the value of the song. So I would just guess that somewhere in that boom, there's several booms in the music business over that 1909 to 1978 period. And somehow I think those songs were a little more valuable than 2 cents. So that's another reason to have a songwriter advocate, because if you'd had somebody in there whose job it was to look after the songwriter's interests and no one else, then, you know, they would have been in there or should have been in there, you know, arguing against that every day, right? And then when the copyright various tribunals got set up after, you know, around 1980 or so, there could have been somebody present at that point. Because of course, what happened after they started increasing the mechanical rate in 1978 was that we suddenly heard about controlled composition clauses and the 3/4 rate, which just happened to knock that rate down, at first at least increase down, back down to 2 cents, right? So yeah.
We should explain, in case for civilians out there, one of the reasons why it's also sort of absurd that record labels care about the compulsory royalty rate on mechanicals is most record labels have what they call a controlled composition clause. And there's a rationale for it. Like, I'm a record label, I signed you as a performer. Any songs you write, we're going to consider controlled compositions, and we're going to get a discount on the songwriter royalties there, because I'm putting like $500,000 into the videos and the marketing and the tour support and stuff like that, right? So that's what a controlled composition clause, it allows the record label to pay the performer usually 3/4 rate, even lower than that in some cases, on the songs that they write.
And you don't pay on free goods. And there's an argument. For example, when I was in the record company, and I would have a publisher call up and say, hey, I saw that you scanned 1 million copies of so and so single, but I've only been paid on 300,000. Where's the rest of my money? And I said, well, we gave, those were actual free goods, that we gave away in order to get those scans that boosted that single, that sold albums that you did get paid on. But here's the deal. If you don't like that, I tell you what I'll do. You pay half my marketing costs and I'll pay you double stat. How's that sound? Yeah, well, no, right. So it's not that there's no science to the control comp clause, but the 3/4 rate part is really not the way to get there, Right. And in Canada, and when you try to explain this to people outside the United States,
you're not allowed to do it.
Yeah, they really don't get it.
In other countries, they don't allow you to privately set the rate, but they see it as usurious to allow record labels to negotiate the rate with songwriters. It's like
it just doesn't even.
They have a way of doing it, and you can't do that, right?
Yeah.
It doesn't get done.
Yeah, it doesn't happen. So back to the CRB. I mean, given that there's all this going on, right? What we know is that we're going to be faced with another, for the duration, basically, we're going to be faced with all these lawyers from the big tech companies, right? So the first thing is to have a songwriter advocate who's just worried about songwriters who they pay for, right? Somebody else, the participants in the proceedings should pay for that advocate. The other thing is that the discovery in this particular case, with this particular set of lawyers, has gotten out of control, absolutely out of control. Because what they're doing now is they're saying, well, you publishers and songwriters say that streaming has been destructive to your income. We don't think that's true. We are going to require you to deliver to us, which they have done, by the way, all your royalty statements for your top 10%, your top 10, I think it's the top 10% of your writers. Since 2009, right? And all your license agreements since 2009. Now, I'm sure there's some redactions and what have you, but wait a minute. Why should I do that? Because here's what because all they're going to do is they're going to come back and they're going to say, yeah, well, we don't think it shows that. I really seriously doubt that anybody's even read any of those things. And this is potentially millions upon millions of pages.
See, if we had our own advocate in there, somebody could say, how much could ask like one of the William Socini lawyers, like, how much did so-and-so earn on this particular song, right? They just, like, I've been part of lawsuits before, and one of the, discovery is kind of a weapon where you try to make the person produce as many documents as possible. So in this case, the streaming services and the big tech companies, basically made the publishers, give all the royalty statements for their top 10% of their artists. I bet you I wonder if any of the artists, not artists, songwriters, wonder if the songwriters have even been notified of this.
I seriously doubt it.
And what's going to happen is, like, one of those songwriters, I'll bet anybody anything, one of those songwriters' royalty statements will end up getting leaked to a tech sympathetic blog like Ars Technica, or what's the other one?
Techdirt, yeah.
Yeah, right. It's going to accidentally get leaked to, like, sort of make the public less sympathetic to songwriters in this situation by leaking, like, a songwriter that really did make a shit ton of money, right? Which is not most of us, right? I guarantee you that's going to happen.
I don't really understand what this has to do with the goal of finding out what a willing buyer would pay a willing seller, for.
Which is what the Copyright Royalty Board is supposed to do.
I think we've
it's
kind of
out of control.
Yeah.
This is like a divorce proceeding where the two
Yes.
sides just get like as many lawyers as possible and just drag the whole thing out with there's no point to any of this. It does not go to addressing the question. It's to punish the other side.
So what we think is that everybody should be limited to one lawyer in the room. Like they can have as many people back at the shop, working on this at the mothership if they want, but no more than one in the room. Why do you need more than one? I mean, if you look at how the DLC operates with the MLC, they've got this one guy who, by the way, used to be the general counsel, one of the senior lawyers at the Copyright Office, who's now representing them, right? They don't have 50
the
lawyers.
DLC is the trade organization for the streaming services.
It's the not exactly. It's DEMA's the trade organization.
Oh, sorry. Yeah.
DLC is who the MLC relates to as the representative of the trade organizations for a whole lot of similar stuff, right?
Yeah.
So, personally, I think they don't need more than one lawyer.
Yeah.
And
what else have you got on your list there, Chris?
Well, if they want to appeal, they need to pay the new rate pending the appeal.
Yeah, why didn't they just pay us, since they're still appealing the rates, right? While they were appealing the rates, they could have paid the higher rate, is what you're getting at, right? And then evened it up later, because that happens actually all the time. If anybody ever has gotten a mechanical royalty statement, or even from BMI and ASCAP, right? Sometimes you get deductions because they have to go back and even something up, right?
Yeah.
So you sort of next year's royalties, if they overpaid you, they pull a little bit back here and there, right? It happens all the time, right?
Yeah.
But that's much fairer to the artist, is pay the higher rate that's being appealed. If it gets appealed, then you even it up going forward on the rest of the stuff.
If you really think after all this shenanigans, after all these lawyers, after all this discovery, after all of this, that somehow you are hard done by, and you need to appeal your case, right? Then pay the damn money, and because, or don't do it, right? Because believe me, the decision to appeal is not made based on how much they're going to have to pay at the higher rate pending the appeal. That is not, because one thing about these guys is that they will make back every penny. I will bet that they will make back every penny that they spent on legal fees in the entire proceeding before we get off this webinar. Because these guys print money. That's what they do. They print money. So they don't care. So the idea that there's some, mental calculation that goes into whether they should pay the higher rate or the lower rate to some songwriters, on a streaming service. I mean, come on, that's a joke. That can't be right. So we talked about, so that's kind of like the main.
That's what we do. That's our life lately.
Points. Yeah. Right. I mean, if we could get those, and I honestly, I'm just guessing, but if I were a judge in viewing, this battlefield, I'd be just about done with the whole crew. I'd be thinking, wait a minute, I need to go home and reconsider my life. What am I doing here? Why is this happening to me? Why are these people doing this to me? Right. And so we're thinking about actually trying to host some roundtables to have some discussion with people, because, the frozen mechanicals thing showed us one thing, which is we need a longer table and we need more people at it. Right. And it's that simple.
Right. So the roundtable idea is something we've been talking about. We've done this before. We've had a couple artist rights symposiums at UGA. We thought we'd have, because there's a music business program at University of Georgia, and I'm the senior lecturer in it, so we can do this. So that's what we were thinking about, is just get a kind of a roundtable where we discuss the Copyright Royalty Board. We are not hostile to the judges. We'd love for the judges to come if they're allowed to.
Absolutely.
Yeah, I mean,
I mean,
this
who
is
would
something
know
we just
better?
want to, we
You
think,
know,
drag this out into the light and see what we get. Hey, by the way, there's a couple bubbling debates in the chat I've been following here. I've been trying to follow your chat here, and a couple people are wondering about why not direct. The problem is we can't license direct because, like, look, if I said, hey, I want 20 cents for my song, right? For, my mechanical royalty should be 20 cents, and that's what I want from you, Sony Music or from, Apple Download Store. The problem is that if I was Sony Music, I go, well, no, thanks. We'll just get a compulsory license because that's 9 cents, right? See, the problem with the compulsory license is it's just the only thing you can do is negotiate lower, which,
right.
by the way, that's another idea for a solution that I have. It's extremely unpopular, but if the, I don't know if it's unpopular, but it's controversial. But if the Copyright Royalty Board wanted to really figure out what the market rate was, they should set the rate plausibly higher than they think the market rate is, and let us kind of compete and negotiate down, right?
Right. Right. Well, George makes the point that the rate ought to be, I think it's 56 cents. And that sounds like a crazy number, but it's not, because it's crazy in the sense that I don't think that you'd ever get anybody to pay it. But it's not crazy because it represents the indexed.
Yeah, if you index the 2 cents from 1909,
that's what it would be.
You get to
Right.
56 cents, right?
And by the way, the 12-cent rate, and the labels really did come to the party on this. The 12-cent rate proposal also includes an index in the out years, so that you get a cost of living bump.
Yeah.
Right. In the out years of the rate period.
Yeah, so that's what the proposal looks like. That's people are starting to kind of coalesce around, is that no more fixing the rate. We're going to get a rate and then it gets adjusted according to inflation, right?
Right.
At least cost of living increase. Somebody out there also is mentioning unions. Oh, unions are problematic for songwriters. Well, they shouldn't be. I mean, I don't see why songwriters shouldn't have unions. I mean, the problem is that the Department of Justice considers songwriters producers of products. So if we try to collectively negotiate a rate or something like that, seen as anti-competitive behavior, and we're slapped with penalties from you get slapped with action from the Justice Department, right?
For mechanical, there is an antitrust exemption, but for everything else, right?
Yeah, for public performance royalties. That's why ASCAP, BMI, and CSAC are not. ASCAP and BMI are supervised essentially by federal judges, is because they're not allowed to essentially collectively negotiate. However, that's also a fairly easy fix. There's, what act is it that has? There are certain organizations that are given exemptions, like I think certain
Sherman Act, yeah,
are given exemptions to that, like
paragraph 1, I think, of the Sherman Act.
NCAA sports, like all of these other, I think like certain nut farmers and certain producers of certain goods are given exemptions from that's why you have farmers collectives that can get together and sell, or the almond growers can get together and sell, sort of figure out what price they want to sell stuff at and then sell it on to the market. Although there's less of an argument for them to have that than songwriters, I will say.
And speaking of that, just in general, it's interesting that the Copyright Royalty Board has now hired an economist, right? Full-time economist. And it does seem to me that there is a logical step there that we should be asking for, to have the economist do an economic impact study of rates that they set, right? Yeah. Why not?
And also
legislation, there'd have to be a CBO score. So
economists can do all kinds of things, like look at price discrimination, if that's happening or if it isn't. Does it appear that prices are being fixed in an anti-competitive manner? There's lots of different economic tools. So yeah, that's pretty good. I didn't really see. Oh, Kevin Klager asked about breakage. Breakage. Okay, so breakage is a deduction where some of the sales, if Chris get this right, some of the sales don't count because in the old days, a certain amount of the CDs that, or I'm sorry, vinyl albums went out there, got broken in transport, or they were just lifted from the stores by employees. That
Fell
was
off the truck, yeah.
yeah, a lot of employee theft when you worked in a record store. You may have, I don't know if any of you ever worked in a record store back when there were lots of record stores. And so it was sort of a way of like reducing your royalty rate because of this sort of breakage. Things might get broken. Not all the product gets sold. Some of it gets stolen. But it got completely corrupted into a much, I mean, it's used in all different kinds of ways. Chris, do you want to maybe explain some of these?
Yeah, so traditional breakage in the physical world was that it was an allocation sort of off the top for anticipated
Linkage of products, things that wouldn't make it defective, return products. Yeah.
Yeah, physically damaged in some way. And so rather than try to figure out each one, God forbid, they just took a flat 10% usually off the units, right?
So yeah, you might sell X number of copies might be shipped or something like that, but you were only paid on 10% less of that.
Mm-hmm. Not to be
well, that's where the accounting started. But breakage
breakage in digital is different. So
yes,
breakage,
that's what I want you to explain.
The term breakage in digital doesn't really mean that. What it means is if you are paid a minimum guarantee, let's say that they pay you $100 in anticipation of you recouping that $100 at the distributor level, right? In other words, if I'm a TuneCore, let's say, and I go to Spotify, and Spotify pays me $100 to license my catalog, and they're anticipating I'm going to sell more than $100, right? Well, if I don't, and there's $10 left over, let's say, what happens to that $10? Does it get rolled forward into a new deal or what? Breakage means that $10 just doesn't recoup, and you have to give me a new $100. And I just keep that $10.
Right.
There's a question as to what happens to that vis-a-vis your artist accounting obligation.
Yes. Do the artists get some of that breakage, or is that just the record company get it?
Yes.
Right. Okay, you could answer that question. You were a record label lawyer for a while, so you know what the answer is always no, the artist doesn't get it, right?
Yeah. Well, it's sort of like the late fee. If you wanted to be mean-spirited, on the late fee waiver money, you could say, well, that's not really royalties. That's a payment of a right that I agree not to exercise for my entire catalog. So I can just keep all that late fee waiver money, right? Which, I don't know what they do. I think a lot of people do distribute it on kind of a black box, a second order black box formula distribution, but they don't have to. I don't think. I think there's an argument that they don't have to, which means almost always means some of them don't, right? But they're not going to pick up the phone and tell you. But that's breakage.
Last question that seems to be in there is how is the copyright? Well, okay, Copyright Claims Board doesn't really have anything to do with. I think you mean performing rights organizations, not prefer. They're separate. They're separate royalties, separate exclusive rights under the Copyright Act. I mean, there's some argument that we could do like other countries do, where there's kind of a uni license where you do, like streaming services do pay a public performance royalty and they pay a mechanical.
Right.
There's a decent argument that it's more efficient that, maybe BMI should be able to issue, that streaming mechanical license and pay their.
That was the argument that I made to everyone who would listen.
Yeah, I mean,
unsuccessfully, but yeah, the argument was that the PROs should be able to issue a unilicense. So we didn't need an MLC, but they should not be able to set the rate for the, in other words, as long as somebody else is setting the rate, they should be able to just administer the mechanical royalty and collect the mechanical royalty because it's the same song, you know, with the same publishers for the same uses with the same users, right? So why do you need this whole other structure? They don't do it that way in the UK, for example. They have the MCPS PRS, you know, license, have done for years.
Right.
But
I believe in Germany too, I think in Germany or France, I think they also issue a.
yeah, I'm sure a lot of them
Like
do.
essentially BMI, you don't have to go to the MLC to get your mechanicals, and you don't have to go to BMI to get your public performance royalties. You can opt to do it all, and that would be helpful. Last thing I know, there's a note on transparency. Well, transparency is a double-edged sword for a songwriter in a way. Like I don't want Netflix knowing what I just licensed the song to HBO for, right? That's going to ultimately, you know, or maybe I do, you know, at some point, you don't want songwriters being forced into the transparency, but necessarily, but it would be nice if maybe we could see kind of what was going on in the MLC, which pays our mechanical royalties. If we could see better, especially the Music Licensing Collective, which is, you know, set up by the 2018 Music Modernization Act, which pays our streaming mechanicals. Like there also have something like 600 million now in black box royalties that weren't assigned to any particular songwriter, and they have to figure out where that $600 million goes. It would be great if that was just publicly available and we could all look at it and see who should get what, you know, just be like the jelly beans in the jar, just crowdsource that, man. You know, you ever seen when like a crime happens, you know, and there's some photo on the internet, like within 3 minutes, people have figured out who's in the photo and like, you know, what kind of car it is. And, you know, like, it's amazing if you crowdsource stuff. I'm all for that. So
yeah, but that's
depends on what kind of transparency. Okay.
right.
I'm all for parts of it. Yeah.
Well, guys, let me jump in here. Unfortunately, I'm afraid we're out of time. However, I know there is a healthy appetite for part 2 of this session. I can promise you.
Yeah.
And it would be an honor and a privilege to host you guys again sometime in the future when your calendars allow.
Well, thank you, Tom.
Well, and
Tom, thank you so much. Really enjoyed it.
Well, thank you. And I really am serious about that because I would like to talk more about possible solutions. I mean, everyone in this session today realizes there's a lot of fucking problems. And some of these entities that we're calling out here would not want us to cast a light on their activities. And I'm so glad that you guys are. And I've never heard of George Johnson before, but he's my hero. And,
oh yeah, he's definitely, if there's a hero in this, it's him.
Long live George Johnson, and we'll have him on as a guest in the future too. But the bottom line is thank you very much for being willing to expend your time and your energy and your own personal resources to fight these fights. These are fights that need to be fought. And so thank you on behalf of everyone out here.
Well, thanks, Tom.
With that, audience, thanks for your continued patronage here. We will be back soon with these 2 rock stars. You just watch. In the meantime, be nice to each other, and we will see you outside and some live music soon. Take care.
Okay. Thanks, everybody.
Thank you.